Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. I recently caught up with the folks at e-Immigration who shared a big announcement. Hot off the presses. Have you heard? E-Immigration is now integrated with the VisaLaw.ai. Over 10,000 users can now connect their e-immigration accounts to VisaLaw.ai, allowing them to generate expert letters, court documents, petition briefs, and entire case packets directly within their case management system. It's case management meets modern drafting, so you can build stronger cases faster than ever. The combination of e-immigration and VisaLaw.ai means what used to take hours can now be done in minutes. Just think how much faster your immigration workflows can be. Learn more at get.eimmigration.com/VisaLawAI, or of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. It is definitely one of those weeks, everybody. Strap in. Things are rough, but do not despair. When I look at the immigration bar, I see pride. I see power. I see a badass mother who don't take no crap off of nobody. Feel the rhythm. Feel the rhyme. Man, I hate the Swiss. Also, shout out to Patricia Cesarez Lodi, who commented on my son's professional Instagram debut from the AILA National Conference to note that she became a patron because he inspired her to do so with his kind end-of-episode sounds. And while I absolutely cannot hate on that, whatever your reasons, loyal listeners, the podcast's Patreon page is happy to have you. And if what you desire is more podcast participation from my son, well, it can be arranged. He can be bought. Flat out. Hope you've got a long commute. Here are your 9 cases. Cool runnings. Our first case is Trump et al. v. Casa Incorporated et al., published by the U.S. Supreme Court on June 27, 2025. This is the birthright citizenship case. Kind of, not really. And it comes to us on an exceptionally long podcast week. All the Supreme Court podcasts will be talking about it, and the full consequences of this decision are going to be hashed out for years to come. But yeah, this birthright citizenship decision's not great. By the time you hear this, you will have surely read dozens of summaries about what very smart people believe that this decision means going forward. Right off the bat, though, this decision is not about birthright citizenship. It could have been. It should have been. It all could have been resolved. It likely will be next term. But instead, here, the Supreme Court decided to punt on that exceptionally important issue and used this decision, this case, as a vehicle to prevent district courts from issuing nationwide injunctions in many contexts. Something the court did not seem overly concerned about during the last presidency. This decision with dissents is 119 pages long, so please listen to Amicus or Strict Scrutiny for their in-depth podcast analyses. I'm just going to quote from some of the dissents here. But before I do, footnote 10 of the majority opinion is exceptionally important for immigration practitioners. Quote, Nothing we say today resolves the distinct question whether the Administrative Procedure Act authorizes federal courts to vacate federal agency action, end quote. It also seems like a class action might work for the particular birthright citizenship issue. Both things, that is, APA challenges and class actions, are very important for immigration litigation going forward, although there's already some case law limiting immigration class actions in some contexts. But that APA quote? Uber important. Lyft important. With all that said, here's Justice Sotomayor dissenting, summing up to me what's really going on. Quote, children born in the United States and subject to its laws are United States citizens. That has been the legal rule since the founding, and it was the English rule well before then. This court once attempted to repudiate it, holding in Dred Scott that the children of enslaved Black Americans were not citizens. To remedy that grievous error, the states passed in 1866 and Congress ratified in 1868 the 14th Amendment, which enshrined birthright citizenship in the Constitution. There it has remained, accepted and respected by Congress, by the executive, and by this court. Until today. It is now the president who attempts, in an executive order, to repudiate birthright citizenship. Every court to evaluate the order has deemed it patently unconstitutional, and for that reason has enjoined the federal government from enforcing it. Undeterred, the government now asks this court to grant emergency relief, insisting it will suffer irreparable harm unless it can deprive at least some children born in the United States of citizenship. The government does not ask for complete stays of the injunctions, as it ordinarily does before this court. Why? The answer is obvious. To get such relief, the government would have to show that the order is likely constitutional, an impossible task in light of the Constitution's text, history, this court's precedents, federal law, and executive branch practice. So the government instead tries its hand at a different game. It asks this court to hold that no matter how illegal a law or policy, courts can never simply tell the executive to stop enforcing it against anyone. Instead, the government says that it should be able to apply the citizenship order, whose legality it does not defend, to everyone except the plaintiffs who filed this lawsuit. The gamesmanship in this request is apparent, and the government makes no attempt to hide it. Yet shamefully, this court plays along. A majority of this court decides that these applications, of all cases, provide the appropriate occasion to resolve the question of universal injunctions and end the centuries-old practice once and for all. In its rush to do so, the court disregards basic principles of equity, as well as the long history of injunctive relief granted to non-parties. End quote. And here is the end of Justice Jackson's dissent. Quote, perhaps the degradation of our rule of law regime would happen anyway, but this court's complicity in the creation of a culture of disdain for lower courts, their rulings, and the law as they interpret it, will surely hasten the downfall of our governing institutions, enabling our collective demise. At the very least, I lament that the majority is so caught up in minutiae of the government's self-serving, finger-pointing arguments that it misses the plot. The majority forgets or ignores that with all its defects, delays, and inconveniences, men have discovered no technique for long preserving free government except that the executive be under the law and that the law be made by parliamentary deliberations. Tragically, the majority also shuns this prescient warning. Even if such institutions may be destined to pass away, it is the duty of the court to be the last, not first, to give them up. End quote. Time will tell how this all shakes out. And that is my version of Trump et al. V. Casa Incorporated et al. Next up is Riley v. Bondi, published by the U.S. Supreme Court on June 26, 2025. This case is about the authority of circuit courts to review denial of withholding of removal and Convention Against Torture protection in withholding-only proceedings. And it's not great for non-citizens. It's not great. Justice Alito authored the majority opinion, with Justices Sotomayor, Jackson, Kagan, and Gorsuch all dissenting, in part, to some degree. Recall this exceptionally complex issue. Here's a general background that I wrote up before even reading this decision. Mostly. When a non-citizen is ordered removed and denied immigration relief and protection, the non-citizen has 30 days to file a petition for review with the Circuit Court of Appeals. The statute requires that a petition for review be filed within 30 days of a, quote, final order of removal, end quote. The petition for review is a relatively short but exceptionally important document that kicks off federal appellate review in most immigration cases. In a normal case, the timing is pretty simple. A non-citizen may, for example, lose an asylum case in immigration court, appeal to the BIA, and, if she loses before the BIA, must petition for review within 30 days of the BIA's decision. But things get a little bit more complicated for non-citizens who have already been ordered removed and have been physically removed and then who return unlawfully and apply for withholding of removal. Or, like Mr. Riley, for non-citizens expeditiously ordered removed by ICE itself and who then seek to withhold or defer that removal order in immigration court. Because no matter the context, right, whether you're coming back and having your final order of removal reinstated and seeking withholding of removal, or if you've been ordered removed by ICE and are then seeking to withhold or defer ICE's removal order, there is still a removal order. It's just trying to be withheld or deferred. But what happens then when someone like this is placed in withholding-only proceedings, has a withholding or CAT claim denied by an IJ and the BIA, and then seeks federal court review? In such a case, the technical removal order likely occurred many months or years in the past. Remember, it's being reinstated, or ICE did it a while ago. The non-citizen is challenging the agency's denial of withholding of removal or CAT protection, which is technically the agency's final decision declining to withhold or defer execution of the removal order. For years, the circuits held universally that non-citizens could bring their petitions for review within 30 days of the agency's denial of relief or protection in withholding-only proceedings. We're only talking about withholding-only proceedings here, guys. That is, until the Supreme Court's decision in Nasrallah v. Barr. Nasrallah had nothing to do with this issue per se, of course. Nasrallah held that non-citizens with serious criminal convictions, otherwise statutorily barred from having the facts of their case reviewed at the circuit level, can have the facts of their case reviewed at the circuit level in the CAT context. The jurisdiction stripping provision, you see, bars factual review of, quote, any final order of removal, end quote, issued against a non-citizen with a serious criminal conviction. INA Section 242A2C. But the Nasrallah court reasoned that CAT is separate from a final order of removal, and so the facts can be reviewed. The Supreme Court reasoned similarly a year or two later in Guzman-Chavez in regards to the custody release eligibility of people appealing the denial of withholding of removal or Convention Against Torture in withholding-only proceedings. Not in a favorable way for non-citizens, don't get me wrong, but the reasoning was based on a similar review of a final order of removal language in the INA. And so we finally come to the Mr. Riley issue. The Second and the Fourth Circuits, to some degree, had essentially held that the 30 days to petition for review began when the removal order itself is issued. That means that many non-citizens denied withholding of removal or Convention Against Torture protection in withholding of removal proceedings, be it post-reinstatement or after ICE expeditiously orders them removed, probably can't petition for review to the circuit court because their petition for review will always be 30 days after the final removal order. Often, in fact, it will be years untimely if the 30 days ticks with the removal order and not the denial of withholding of removal or CAT protection, because those things, that is, deciding withholding and CAT in immigration court, that takes months and sometimes doesn't even kick off for well over 30 days after the removal order is actually issued. So Mr. Riley's case is occurring in the FARO context. ICE has ordered him expeditiously removed, and he was then placed in withholding-only proceedings because he had a reasonable fear of persecution or torture. He petitioned for review within 30 days of the denial of withholding of removal by the BIA, but well after 30 days of ICE's order of removal. The Fourth Circuit dismissed Mr. Riley's petition for review for this reason, and the Supreme Court took it up to resolve this circuit split. In this case, the court vacated and remanded the Fourth Circuit's dismissal, so a technical win for Mr. Riley. But all is not well for non-citizens. To the Supreme Court majority authored by Justice Alito, the resolution of the issue depends on answering two questions. Is the 30-day petition for review deadline jurisdictional? And is denial of relief or protection and withholding-only proceedings a, quote, final order of removal, end quote? So stated, we're going to be in trouble. The court split the baby in a manner that is going to be pretty bad for non-citizens. Addressing the second question first, denial of relief or protection in withholding-only proceedings is not a final order of removal that starts the 30-day petition for review deadline. That 30 days is tethered to the initial final order of removal, meaning that petitions for review in cases like this will almost always be untimely if you wait to the denial of withholding of removal. That is really, really bad for non-citizens. As to the first issue, though, post Santos Zakaria, the 30-day petition for review deadline is not jurisdictional. So that's great. But it's a claims processing rule, meaning that all oil has to do is assert the rule, and a circuit will likely refuse to consider a petition for review in all such cases. Because the government didn't assert the claims processing rule here, the matter was remanded. But oil probably didn't assert the claims processing rule because they thought that the 30-day rule was jurisdictional like all of us. Now they know. You best believe that going forward, oil will be asserting the claims processing rule, at least under this administration. So to me, that's everything. But here's how we got there. So if you want to skip ahead, be my guest, because it's a long one, but I think it's important. If you're still here, here we go. As I mentioned, and unlike other cases where this is occurring, Mr. Riley was ordered removed by ICE itself. He was ordered removed because he overstayed his visa in 1995 and then spent many years in prison for a drug trafficking conviction. ICE deemed the drug trafficking conviction an aggravated felony and so ordered him removed itself rather than giving him full-on removal proceedings, as ADEPA and IRIRA permit when a non-citizen has a conviction that ICE deems an aggravated felony. To do so, ICE first issues a notice that says, "We think your conviction is an aggravated felony." The non-citizen has 10 days to challenge that. 10 days. And that's a challenge to ICE itself, not to a judge or anything. If no challenge is made, or a challenge is made and ICE inevitably rejects it, the non-citizen is issued a, quote, final administrative review order, end quote, known as a FARO. Let my people go. ICE will then execute that order and remove the non-citizen unless the non-citizen is deemed to have a reasonable fear of persecution. If they pass their reasonable fear interview, they're put in withholding-only proceedings to pursue withholding of removal relief and Convention Against Torture Protection. But they still have the FARO. They're just trying to get an IJ to withhold or defer it. A non-citizen in this crazy expedited pseudo-proceeding does have another option. They can petition for review that FARO. That is, the removal order. But I'm not sure whether they are then permitted to pursue withholding of removal or CAT protection alongside that in the agency. And regardless, you are then litigating two things at once. As you'll see later, I think you can pursue two things at once. Mr. Riley did not petition for review the FARO. He didn't challenge the aggravated felony finding. And to be honest with you, he probably didn't have a good argument. His petition for review probably would have been dismissed. His conviction is probably an aggravated felony, so there would have been no point to petitioning for review. And so his decision was, quote, seeking relief under the CAT. Mr. Riley told an immigration officer that a wealthy and powerful Jamaican drug kingpin had it in for Mr. Riley's family, had killed two of his cousins, was influential with the police and politicians in Jamaica, and would likely kill Mr. Riley if he was returned to any place in that country, end quote. DHS concluded that this wasn't good enough to even get the opportunity to pursue a claim before an IJ, but an IJ disagreed. The IJ then provided full-on withholding-only proceedings and ended up granting Convention Against Torture deferral. That is no small thing. But the BIA disagreed and vacated the IJ's CAT grant. Mr. Riley petitioned for review the BIA's reversal to the Fourth Circuit, 3 days after the BIA ruled. But of course, all of that took much, much, much more than 30 days to complete. We're talking a full-on merits hearing before an IJ and then litigation before the BIA on appeal. As I mentioned, the Fourth Circuit dismissed finding it lacked jurisdiction. The reason was because the court believed that the 30 days began when the FARO was issued many months before and not the final order denying CAT protection. While that's based on the statute, it's really based on what the Supreme Court started in Nasrallah that I just kind of discussed. Big circuit split developed on this issue to varying degrees. In the Riley case, very similar to the Patel litigation, the Solicitor General of the United States agreed with Mr. Riley in large part, and so did not really defend the Fourth Circuit's position. But the Supreme Court wanted this case, and so appointed Stephen J. Hammer to argue in support of the Fourth Circuit's non-citizen adverse position. A Google search shows that Mr. Hammer clerked for Chief Justice Roberts, among other judges. And the Supreme Court majority largely but not exclusively agreed with Mr. Hammer's position and the Fourth Circuit. Long summary short, and relying on its recent Nasrallah and Guzman-Chavez decisions, the Supreme Court majority held that the statutory reference to an order of removal, which triggers the 30-day petition for review deadline, can only refer to the order of deportation itself. It does not include decisions to withhold or defer execution of the removal act. The INA defines an order of deportation as an order, quote, concluding that the alien is deportable or ordering deportation, end quote. Applying here, the FARO was final when ICE ordered it because the law doesn't permit an IJ or the BIA to review a FARO per se. Mr. Riley needed a petition for review that FARO within 30 days of ICE issuing it. The majority rejected Mr. Riley and the U.S. government's arguments and held flat out that, quote, an order denying relief under the CAT is not a final order of removal and does not affect the validity of a previously issued order of removal or render that order non-final, end quote. That rule, so stated, would seem to apply equally to withholding only proceedings post-reinstatement of a final order of removal in addition to this FARO context, as would the logic of this decision. Although like with Nasrallah itself, that quote doesn't technically apply to INA withholding, right? Just CAT protection? But to me, the logic has always applied equally, and the circuits have kind of believed that. I wouldn't hold my breath. It seems that CAT deferral and withholding of removal under the INA, along with withholding of removal under the CAT, are all subject to the rules being said right now, if they're happening in withholding only proceedings. What should people like Mr. Riley do in practice? While reviewing the majority's rejection of the Solicitor General's arguments, it seems that the Supreme Court would have the Mr. Rileys of the world petition for review the FARO and then alert the Circuit Court to the pending withholding-only proceedings, after which the Circuit should probably stay the FARO petition for review until denial of withholding of removal can be concluded, or, of course, until withholding of removal is granted. Cumbersome, expensive, and often unnecessary, and maybe even frivolous if it's a per se aggravated felony, for example. And perhaps most importantly, it appears to be a petition for review saving process completely unavailable to denials of withholding removal and withholding only proceedings post-reinstatement, because those final orders would have occurred much more than 30 days prior, unlike a FARO. And let's be honest, that is a large chunk of these withholding only denials. Pretty big caveat on that, though. While I believe the logic may flow to withholding only post-reinstatement, and while some of the circuits split below arose in this context, the applicability to withholding only review post-reinstatement does remain somewhat unclear. This case isn't directly on point after all, and it may be the case that a rule ultimately develops such that by petitioning for review ICE's decision to reinstate itself, you can save the withholding-only denial petition for review as well in a cumbersome process similar to the one being suggested for FAROs. People smarter than me, who I am smart enough to text and email with, have been combing for support for this argument and already have some combed ammunition. Or maybe OIL will develop a policy not to invoke the claims processing rule in such cases, given how exceptionally unfair doing so would be. But even if all of that is true, it is a bad day for federal court review of FEAR claims, and all of this is an absolute landmine for circuit practitioners to navigate. So there you go. The quite non-citizen bad ruling. But hey, at least the 30 days isn't jurisdictional. It's a claims processing rule, like so many other things are now. After all, Congress didn't mention jurisdiction in the 30-day petition for review rule, for example. That means if, like here, OIL doesn't timely assert the claims processing rule, a circuit court can excuse a non-citizen's failure to petition for review within 30 days. And that applies to all petitions for review, not just denial of withholding and CAT in withholding-only proceedings. But again, I wouldn't hold my breath going forward. Justice Thomas concurred, as he so often does, to posit that actually an even harsher rule might be plausible. Justice Sotomayor and 3 other justices dissented on the 30-day stuff, calling the majority's holding, quote, incomprehensible, end quote. And all dissenting justices, other than Justice Gorsuch, write that, quote, time will tell whether the court will extend its illogic beyond politically disfavored non-citizens, end quote. And points out that much, if not all, of the Supreme Court majority seems to have recently taken the opposite track with a similar issue not involving non-citizens. That's all I got here, but to steal from Rekha Sharma Crawford and Jeremy McKinney. As those two smart people write, all this talk about claims processing rule obligations does seem to reinforce what attorneys have consistently argued in the deficient notice to appear context. If a deadline or document requirement is a claims processing rule, the agency, or DHS, must also meet that rule or explain why equity excuses it. In particular, this applies to curing a bad NTA under matter of Fernandez and matter of RTP, and the government should be held to their burden to establish why equitable tolling allows for the deficient NTA to be cured years after the fact. The Riley decision clarifies that the party invoking the claims processing exception bears the burden of meeting that threshold requirement. So, hold the government to their burden, and when it's the non-citizen who's got an issue with the claims processing rule assertion, be prepared to vigorously argue for equitable tolling in all contexts. That is, when the non-citizen has the claims processing rule burden. Hey, it's some positive from what seems to be an otherwise very harsh adverse decision to non-citizens. Want to hear even more about this decision? The National Immigration Litigation Alliance, NILA, is doing a CLE webinar on July 10th at 3 p.m. Eastern. You should attend! What are you waiting for? And that is Riley v. Bondi. Oh my. Next up is Lainez v. Bondi, published by the Second Circuit on June 23rd, 2025. This case is about derivative citizenship. Judge Cabranes dissented. Mr. Lainez was born in El Salvador in 1970. His, quote, father's name appears on his birth certificate, but his parents never married, and his father did not participate in raising him, end quote. As a new father, I cannot condone that. But it's about to be the best gift Mr. Lainez ever received. Gotta love immigration. He was admitted to the United States as a lawful permanent resident with his mother in 1979, when he was 8 years old. Then at 14, his mother became a naturalized U.S. citizen. His father never did and appears to be out of the picture. Mr. Lainez ended up in removal proceedings many years later due to some crimes that are probably aggravated felonies. He got ordered removed, and although he was asserting that in fact he was a citizen, he was pro se for much of it. No easy task, even for an attorney, that is, applying the old citizenship laws. After being ordered removed, he sought a certificate of citizenship with the assistance of counsel and brought it all the way back up to the Second Circuit, which to me confusingly affirmed that a district court lacks subject matter jurisdiction over the matter, but also that he could pursue this claim by moving to reopen his immigration case and then bringing that to the Second Circuit. Weird. But it succeeded, and here we are. Where Mr. Lainez succeeded. Bigly. He's a citizen. Because of course, and until our next constitutional crisis, U.S. citizens can't be removed no matter how bad their conduct was. They're U.S. citizens. The applicable citizenship law is always the law at the time of the alleged triggering event. Here, that's 1985, when Mr. Lainez was 14 years old and his mom naturalized. That makes it former INA Section 321A, which in relevant part makes a child whose parent naturalizes a citizen automatically upon, quote, the naturalization of the parent having legal custody of the child where there has been a legal separation of the parents, or the naturalization of the mother if the child was born out of wedlock and the paternity of the child has not been established by legitimation, end quote. So long as the child is, quote, residing in the United States pursuant to a lawful admission for permanent residence at the time of naturalization, end quote, with some caveats not relevant here. Now, Mr. Lainez easily meets almost everything, right? Assuming, of course, that his paternity has not been established by legitimation. If paternity has not been established by legitimation, he's a citizen. If it has, he's not. Wild and arbitrary AF, right? Legitimation turns on the law in the relevant jurisdiction where that action could have occurred, and so here that's El Salvador. Legitimation could have actually occurred for former INA purposes here, in 1983, when Mr. Lainez was 12 years old or so, because El Salvador changed its constitution at Article 36. Prior to 1983, there were definitely different classes of children in El Salvador, legitimate, illegitimate, etc.
And it seems that Mr. Lainez's father didn't do anything to legitimize Mr. Lainez. So again, bad for Mr. Lainez, the child, but maybe good for Mr. Lainez, the adult. And it seems that Mr. Lainez's father didn't legitimize him. But in 1983, Article 36 was amended and granted, quote, all children equal rights before their parents, end quote. In El Salvador, of course. So the argument goes, Mr. Lainez was essentially legitimized by law in 1983, tanking his citizenship claim now. Oyle's argument was rejected by the Second Circuit majority. To the court, legitimation as used at former INA Section 321 requires some sort of affirmative act by the father. Without getting into the weeds, quote, a long line of precedent from this court and the BIA hold that the general statute conferring equal rights on all children regardless of a parent's marital status legitimates those children. But such a law does not necessarily establish their paternity by legitimation as those terms are used in former Section 321, end quote. Sneaky, sneaky. Really the best of both worlds for children of absentee dads under the old citizenship law. They get the rights of legitimation under the foreign law, but can still be deemed U.S. citizens when their moms climb mountains to get to America and get it for them, because paternity is not being established. Paternity and legitimation are related but distinct things, explains the court. In America, for example, quote, paternity proceedings are intended to establish the identity of the father, while legitimation establishes the legal status of the child, end quote. Even the BIA seems to have recognized the distinction in a footnote in its own precedential decision analyzing this very Salvadoran 1983 change, matter of Mayorga from 2001, and then again in matter of Cross in 2016. Cross isn't Salvadoran, I believe, but still, recognizing the distinction. Relying on this and Loper Bright, the Second Circuit ruled that Congress knew that there was a difference between legitimation and paternity when it wrote the INA provisions in 1952, and so those terms are distinct. Quote, as a general matter, the use of different words within the same statutory context strongly suggests that different meanings were intended, end quote. Quote, establishing paternity means establishing who has parental rights with respect to a given child, end quote. It's the parent's rights vis-a-vis the child, while legitimation is more of the child's rights vis-a-vis the parent and the country. The former statute's inclusion on paternity then, quote, allowed a father effectively to block his children from deriving U.S. citizenship in order to protect the rights of non-citizen fathers, end quote. Which is legitimate to the Second Circuit. If you establish paternity, a father earns that right, that is, to block U.S. citizenship. So goes the logic. But not if you don't establish paternity, even if the child has been legitimated. Have I said the word enough for you guys yet? That is legitimation. If a father hasn't taken the steps to earn paternity, quote, it would make no sense to give a father veto power over the child's citizenship to protect non-existent rights, end quote. Really smart legal arguments are being made here by Mr. Lainez's counsel, it would appear. Back to the 1983 Salvadoran change. That was all about legitimation, not paternity by legitimation. That gave Mr. Lainez equal rights in El Salvador to children born in wedlock or recognized by their fathers is besides the point. And here, Mr. Lainez's father, quote, did not take any relevant actions to establish his paternity by legitimation under Salvadoran law, end quote. That his name was on the birth certificate also doesn't matter. Even Oyle conceded this, and the Second Circuit agrees. Quote, while there is no dispute about who Mr. Lainez's father is, that does not mean he obtained parental rights, end quote. Meaning, not only does Mr. Lainez get to stay, he could have been voting since the 1980s. What a case. Pin this one for your review if you ever get an old derivative citizenship client. And congratulations, Malik Havalik, Dustin P. Smith, and Valia B. Hayes for petitioner. And that is Lainez v. Bondi. Moving on to matter of Mayorga Ipina, published by the BIA. This case is about crimes involving moral turpitude and bond. Another precedential mandatory detention decision from the BIA. Mr. Mayorga Ipina has a 2017 conviction for indecent exposure in violation of Section 18.2-387 of the Virginia Code. In 2020, an immigration judge denied bond, but then another judge reconsidered that sua sponte and granted bond by finding that the conviction is not a CIMT. DHS appealed. Mr. Mayorga Ipina was released during the appeal, and there is no indication in this decision that he has done anything in the years since his release to warrant redetention. While convictions for indecent exposure can be CIMTs, the IJ found that this particular Virginia statute is not categorically so because, quote, the statute punishes activities that are not for the purpose of arousing lewd or lascivious interest, such as the exposure of a breast for sunbathing, political protest, or an interest in nudism, urinating in a public area, or adjusting one's underwear for comfort, end quote. If true, that's pretty important because the statute probably isn't divisible on those issues. And also quite important because Congress saw fit to not even permit people with CIMTs to seek bond before an immigration judge. They are subject to mandatory detention without any individualized analysis, no matter when that conviction occurred. CIMTs require a mens rea of knowingly, intentionally, or criminal recklessness, and conduct that is reprehensible in that it, quote, shocks the conscience and violates a moral norm, end quote. The Virginia statutory text here in turn reads that, quote, every person who intentionally makes an obscene display or exposure of his person, or the private parts thereof, in any public place, or in any place where others are present, or procures another to so expose himself, shall be guilty of a Class 1 misdemeanor, end quote. That's a culpable mental state to the BIA, intentional, right? But is it sufficiently shocking and moral norm violating? I'll tell you one thing, not at Black's Beach in San Diego. I'll tell you that much. Check it out for AILA 2026, everybody. Under 12-year-old BIA precedent, for a crime like this to be a CIMT, quote, the statute prohibiting the conduct must require not only the willful exposure of private parts, but also a lewd intent, end quote. The Virginia statute here doesn't actually use the word lewd, but it does refer to obscene displays or exposure. And the Virginia Code defines obscene in 19th century terms that I cannot help myself but read in full. Quote, that which considered as a whole has as its dominant theme or purpose an appeal to the prurient interest in sex, that is, a shameful or morbid interest in nudity, sexual conduct, sexual excitement, excretory functions or products thereof, or sadomasochistic abuse, and which goes substantially beyond customary limits of candor in description of representation of such matters, and which, taken as a whole, does not have serious literary, artistic, political, or scientific value, end quote. Quite frankly, that Virginia statute seems possibly unconstitutional. But with that definition, the BIA does not believe that the IJ's, quote, examples of topless sunbathing, urinating in public, and adjusting one's underwear for comfort would result in a conviction, end quote. The BIA also relies on a 1974 Virginia Supreme Court decision in support, and it appears that Mr. Mayorga Ipina did not provide Virginia case law to the contrary. To the BIA, all that means that no matter what Mr. Mayorga Ipina has or has not done, since his release, he must now be redetained without even the possibility of showing that he is not a danger or a flight risk. Because that is what mandatory detention means. It's also probably going to be quite bad for his removal proceedings in chief. And that is matter of Mayorga Ipina. Our next case before we take a break, yes, I know it's crazy that we haven't yet taken a break, is matter of CIRH and HSVR, published by the BIA. This case is about nexus. Attorney General Bondi decided to make it precedential. It didn't used to be. The respondents are a mother and child from Honduras, but only the mother's claims are at issue. Multiple male relatives of the mother's mother were killed between 2011 and 2018 in Honduras. I'm positive there's got to be more to this story, but it's not discussed in this BIA decision. An immigration judge granted asylum, providing this mother and daughter a path to green cards. And everybody agrees that they're scared to go to Honduras. The BIA reversed, and the Attorney General has made it a precedential reversal on nexus. Asylum nexus requires a showing that at least one central reason for the harm suffered or feared is on account of a protected ground. Here it was particular social group, quote, family relationship with her mother, end quote. The grant was a problem to the BIA because even the IJ acknowledged that the respondent testified that, quote, no one knew who killed her family members or why, end quote. The IJ relied on Fourth Circuit precedent, where this matter arises, to conclude that a showing of motive is not necessarily required to satisfy nexus. But the BIA doesn't read those Fourth Circuit decisions for that proposition. I personally did not go back to read those Fourth Circuit decisions to see whether the IJ was more right than the BIA, but you can. In any event, quote, while we agree that explicit statements from the persecutors regarding the protected ground are not required, there must be some showing of a connection beyond speculation such that the alleged harm is not solely stemming from statistical likelihoods or unfortunate coincidence, end quote. Motive is indeed important under Supreme Court precedent, although direct evidence is not required. Quote, while it is regrettable that so many of the respondents' relatives have been killed, the respondent acknowledged that she and her family do not know whether it was the same perpetrators who killed the many deceased relatives, end quote. To the BIA, the best the respondent had was a rumor going around town that the family was going to be killed. Without more, and without even knowing who killed the relatives, quote, the facts are too speculative and too tenuously connected to constitute even circumstantial evidence that could underpin a determination that nexus has been established, end quote. Plus notes the BIA in a footnote, all those who were killed were males, and the respondent and her daughter are not. So as reflected by the BIA, it does seem to be a pretty weak case on nexus that I'm sure most asylum claims can distinguish from. Remanded by the BIA for cat protection, though, but only because it wasn't discussed previously by the IJ, it seems. And that is a matter of CIRH and HSBR.
Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez Immigration Bonds take it from there. They help families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process, and they typically issue refunds within 1 to 2 weeks of receiving the I-391 bond cancellation notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your client stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40. And for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They got those too. They're family-owned and have been in business for 75 years. Gonzalez & Gonzalez Immigration Bonds. Efficient, supportive, and trusted. Visit immigrationbond.com, click on the link in the show notes, or call at 833-409-9200.
Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Welcome back to what is largely the relief cases. First, Zalaya, Orellana v. Bondi, published by the Fourth Circuit on June 24th, 2025. This case is about cancellation of removal. And man, is it a rough one. Mr. Zalaya Orellana is from Honduras and entered the United States without authorization in 2003. He was placed in removal proceedings in 2014, meaning he just barely got the 10 years required to pursue non-LPR cancellation of removal. As a basis for the hardship showing, Mr. Zalaya Orellana asserted that his U.S. citizen daughter's mental health diagnosis and the dangers that she'd face in Honduras with him met the standard. The IJ seems to have struggled a bit due to Mr. Zalaya Orellana's prior relationship with alcohol and related criminal offenses, but granted non-LPR cancellation of removal, primarily because of how the IJ believed the daughter would suffer with her father if removed to Honduras. The daughter, of course, being a U.S. citizen, but she joined the father apparently. No small or easy victory to achieve. But as we all know, cancellation grants are severely backlogged because Congress saw fit to tie IJ's hands by only permitting 4,000 grants a year, no matter how worthy a non-citizen's case is. Because of that, there's a backlog. And because of that, the IJ simply indicated an intent to grant when a number becomes available. That was back in 2019. Fast forward to 2023. A number's available, but the IJ has retired, meaning that it's got to be assigned to another IJ to officially grant the case. But that never happened, because DHS filed a motion to recalendar proceedings. I guess that this is kind of a form of admin closure? Gasp. The reason for recalendaring is because in the interim, literally 1 month before DHS's motion, and 1 month before what I guess should have been a grant, Mr. Zalaya Orellana was arrested for, quote, felony hit and run in violation of Virginia Code Section 46.2-894, end quote. A few months later, in recalendared proceedings, the IJ denied cancellation, finding that based on the entire record, which included this new arrest and apparently continuing problems with alcohol, that Mr. Zalaya Orellana was not a person of good moral character and didn't deserve the relief as a matter of discretion, as the cancellation statute also requires. We just never talk about those elements on the podcast. On appeal, Mr. Zalaya Orellana made quite the argument that under 8 CFR Section 1240.21 and Operating Policies and Procedures 17-04 of EOIR, the IJ actually needed to issue the first IJ's grant within 5 days of being notified that one of the 4,000 visas were available. That date would have apparently been no later than January 20th, 2023, 5 days after DHS itself notified EOIR that the background checks had cleared, and before the arrest for the hit and run. The BIA rejected this argument. And surely for jurisdictional reasons, Mr. Zalaya Orellana brings only that regulatory and OPPM argument to the Fourth Circuit, which rejected them. And can I just note that the Fourth Circuit put in a bit.ly short site to the OPPM in a footnote, which totally means that shortening URLs and including them in briefs is fair game. If you know, you know. So, that regulation. Quote, when grants of cancellation are no longer available in a fiscal year, further decisions to grant such relief must be reserved until such time as a grant becomes available under the annual limitation in a subsequent fiscal year, end quote. As to the OPPM, it advises that IJs should draft decisions in cancellation cases but not make them public. Then, when EOIR determines that a visa number is available, it notifies the IJ that the decision may be issued. Quote, within 5 days of being notified that a number is available, the IJ will revise the decision, if necessary, and sign in return to the court administrator for issuance, end quote. So that's the language being relied on heavily here, it seems. IJs also need to get updated DHS background checks. And that same OPM, though, says that if the IJ who drafted a decision is unavailable when a number becomes available, the new IJ, quote, is not bound by the original IJ's preliminary decision, but should consider, among all the other facts and circumstances present, that the original immigration judge had the opportunity to see and hear the witnesses testify, end quote. How mushy. And not amazing for Mr. Zalaya Orellana's arguments. But on the other hand, there was no cause to wait 2 months to take action in this case. It does seem that the reserved decision of the first IJ should have been issued within 5 days of the background check receipt, which had come back clean, given that the new arrest hadn't happened yet. Interesting stuff. But again, the Fourth Circuit disagreed. First, the OPPM, like pretty much all OPPMs I believe that come from EOIR, don't create rights enforceable by private parties. And while the Accardi doctrine requires agencies to follow their own procedures or regulations, it doesn't usually apply to an agency's internal memoranda. Restated OPPMs generally don't require anything of IJs and EOIR staff. They're just guidance. Keep that in mind as Ms. Owens and EOIR continue their internal memoranda blitzkrieg. Though we all know that in practice, IJs probably put their job on the line by ignoring OPPMs. Not legally significant, it would seem, to the Fourth Circuit. Plus, cancellation is very discretionary, and under the law, the first IJ technically could not grant anything officially. Nothing was final. What a mess of Congress's own intentional making. But so, quote, on those facts, petitioner had no legal entitlement to a decision within 5 days of the visa becoming available, end quote. To the Fourth Circuit, it's not so dissimilar to if Mr. Zalaya Orellana had done further bad acts while an actual grant was on appeal. There's no final agency action yet, so things are fluid and can change. Not only that, but the Fourth Circuit does not see the OPPM as requiring a decision within 5 days anyway by its text. At least when it's here, the first IJ is no longer available. And so, although he was very close, Mr. Zalaya Orellana lost his case and is removable. I wonder if he was ever actually convicted. Heck, I wonder if he ever did it. And that is Zalaya Orellana v. Bondi. Moving on to Zayaquin Zerom v. Bondi, published by the First Circuit on June 25th, 2025. And I very much hope that I pronounced that name correctly. This case is about cancellation of removal and hardship. The petitioner and his partner are from Mexico and Guatemala, it seems. They've been here over 10 years and have U.S. citizen children, and so applied for non-LPR cancellation of removal in removal proceedings. But an immigration judge held that the lead petitioner, the husband, and his partner had failed to establish that their removal would cause the requisite exceptional and extremely unusual hardship to at least one of said children. Whether the children went with the couple or remained in the U.S., as the law requires, by the way, they were both considered, both of those circumstances. The BIA affirmed. After all, apparently the parents are healthy and can work, and the kids speak fluent Spanish, and the couple already have a home in Mexico. Other things, too. The First Circuit affirmed. The issue is reviewable post-Wilkinson because the only question is whether all these facts meet the legal standard for exceptional, extremely unusual hardship. That legal standard does not require unconscionable hardship, explains the First Circuit, and the BIA for that matter. But it must be more than the expected harm from generally tearing apart parents from their U.S. citizen children or forcing U.S. citizen children to move abroad to a country they don't know. That was the whole point to the First Circuit of Congress getting rid of suspension, instituting this intentionally high standard for cancellation, and limiting grants to 4,000 grants a year. All the things routinely discussed on this podcast and that can make immigration law so harsh. It's a totality analysis that is hardship, and it includes many factors, including hardship to the non-citizens themselves, but only, quote, insofar as they may affect the hardship to the qualifying relative, end quote. Like, for example, I guess, if a respondent was going to likely be killed in the country of removal, I imagine that would cause hardship to the qualifying relative child. In any event here, the first challenge from the petitioners was to the agency's rejection of their argument that they'd be unable to financially support their children, whether the children remained in the U.S. or came with the parents. The agency held that there was no evidence to support this claim, and the petitioners called that finding, quote, outrageous, end quote. Maybe so, maybe not, but that is a challenge to the agency's fact-finding, not to whether agreed facts meet the legal standard. Because, right, they're challenging the agency's factual conclusion about supportability. And a challenge like that is barred by Wilkinson and the statutes that Wilkinson relies on, explains the court. Moving on then to reviewing the agreed facts for whether they meet the hardship standard, the First Circuit does not choose a standard of review just yet. Recall that budding pseudo-circuit split between substantial evidence review, abuse of discretion, or maybe something else? All deferential, though. No matter the review to the First Circuit, it's going to be deferential per Wilkinson, and the court doesn't see sufficient error from the BIA. A decrease in educational opportunity seems to be a hardship expected in cases like this, as does forcing children to leave a country that they've lived in their entire lives, particularly given their apparent fluency in Spanish and lack of any learning disabilities.
Nor did the agency ignore hardship facts to the court. That the petitioners are good people and have no other path to legalizing their status just isn't overly important to immigration law, to paraphrase the First Circuit. Or at least the court doesn't really see why any of that has to do with the qualifying relative children suffering hardship. And, although it's quite clear that the agency didn't devote much attention to the evidence of crime and bad conditions in Mexico and Guatemala, the BIA did seem to address that in 2 sentences a bit, and that was enough for the First Circuit. Finding some other challenges underdeveloped, the First Circuit affirmed that the agency has no hardship finding, meaning that this couple will very likely be removed. If you believe people like this family, who have lived in the U.S. for a long time, appear to be very good people, and appear not to have a criminal record, should have a more humane path to remaining in the U.S., I've included an immigrants list link in the show notes. Great event at Ala National, by the way, and all the immigrant list awardee recipients were exceptionally well-deserving. And that is Ziaquin Zeron v. Bondi. Moving on to Mejia Ponce et al. The U.S. Attorney General, published by the 11th Circuit on June 23, 2025. This decision is about particular social groups. Other asylum elements and other issues were denied by separate unpublished opinion. Since at least 1985, the BIA has defined a particular social group as one that is immutable and defined with particularity and social distinction, although that latter portion used to be called social visibility. For years, the circuits followed suit, explains the 11th Circuit, applying Chevron deference to the ambiguous concept of a particular social group and deferring to the BIA's reasonable definitions. The 11th Circuit was one of them. But Chevron deference is no more. Loper Bright has arrived. You must have been at my panel at Ala National. And so now, as I've been arguing on all of these panels for a year, quote, Ms. Ponce asks us to take a fresh and unencumbered look at the meaning of particular social group. She proposes that the term be read to mean 2 or more describable, distinctive, or distinguishable humans sharing common characteristics that can be referred to in the aggregate, end quote. And why not? Chevron's dead, and as the 11th Circuit explains in a footnote, the United Nations has a broader definition for particular social groups than does America, even though it's all based on the same treaty. Yes, indeed. That's the argument. The 11th Circuit didn't bite, though. Although not because it couldn't. In a footnote, it left a bit open the issue of stare decisis to pre-Loper Bright particular social group decisions, that is, whether they bind. To this panel, though, another panel answered this question in 2019 without relying on Chevron deference. What a pivot. A prior panel believed that the best reading of the particular social group statute, in 2019 apparently, requires a definition similar to the BIA's. Specifically, that prior panel, Perez-Zenteno, reasoned that the particular social group phrase isn't simply a catch-all for asylum claims, and so entails, quote, obvious, discrete, and measurable factors as immutability, identity, visibility, homogeny, and cohesiveness in order to give meaning to the term, end quote. Not quite immutability, particularity, and social distinction, though, right? It's kind of close, but I don't know. I feel like there's some creative lawyering to do there, now that, to me, the 11th Circuit has defined particular social groups slightly different than the BIA. To me. Applying that definition here, the panel rejected the proposed social group of, quote, Honduran business owners who are perceived as having wealth and are targets of threats and extortion by criminal gangs, end quote. Too broad to the court. At a minimum, Ms. Ponce must do something, quote, to limit or circumscribe this large and diverse group in any way, end quote. So I assume, getting to the facts in their unpublished opinion, which I did not read, the court denied Ms. Ponce's petition. And that is Mejia Ponce et al., the U.S. Attorney General. We have reached the end of the episode. I personally didn't think it was possible, but here we are. Shows how much I know. Last, we have Gurkarat Singh v. Bondi, published by the 7th Circuit on June 24th, 2025. This case is about asylum and reasonable relocation. Mr. Singh is a Sikh from India He's a member of the separatist Man political party. The rival Congress Party started threatening him. A year later, while hanging up flyers for a Man Party-sponsored blood drive, Congress Party members beat him with baseball bats and hockey sticks for 10 to 12 minutes. That is a long time to be beaten by such things. Just think about that. When Mr. Singh attempted to report the attack, local police refused to do anything and advised him to join the Congress Party. Congress Party members beat him a second time a few months later, this time threatening to kill him. Same thing with local police this time too. And that's when Mr. Singh left India for the United States, where he applied for asylum and related relief and protection. An immigration judge found Mr. Singh credible but denied. 25 years old and in good health, the IJ reasoned Mr. Singh could relocate in India and maintain a livelihood. That finding was probably only possible because the IJ also believed that Mr. Singh hadn't suffered harm rising to the level of past persecution. The BIA summarily affirmed, as did the Seventh Circuit. But a 10 to 12 minute beating with baseball bats? I digress. BIA precedent mandates that the BIA apply a dual review standard for mixed questions of law and fact. Unsure if circuit precedent necessarily does too, but if BIA precedent applies, and here the Seventh Circuit is assuming it does, it means that, quote, while the BIA reviews an IJ's factual findings for clear error, it reviews legal questions, including the application of law to fact, as plenary, end quote, which I think means de novo. Now, Mr. Singh believes that means that the reasonableness of relocation is a legal issue that the BIA reviews de novo. Seems he's right, too. So here, where the BIA said that it discerned no clear error with the IJ's finding on that account would appear to be error, right? That's the standard of review for fact issues, not legal ones. Not a reversible problem, said the Seventh Circuit. The BIA, after all, cited the matter of Burbano. Under that decision, the BIA, quote, may affirm in a summary fashion when its independent review of the record yields conclusions that coincide with the IJ's decision. The BIA's invocation of Burbano thus demonstrates that the BIA did not defer to the IJ. Instead, it exercised its independent review authority and concluded that Mr. Singh could reasonably relocate, end quote. No matter the language it used elsewhere? Wild. But also, the court explains that Mr. Singh, quote, waived any contention that the BIA's Burbano statement was mere parroting of the correct standard of review or an insufficient indicium of independence by failing to file a reply brief, end quote. So that does seem important to this decision. On the meat of the IJ and the BIA's relocation analysis then, and assuming no past persecution, the Seventh Circuit believes that Mr. Singh is in trouble, legally speaking. That's because he, quote, conceded at oral argument that it is possible for low-level Man Party members to avoid persecution by relocating within India, end quote. But he asserted that for himself, quote, personal circumstances make relocation unreasonable for him, end quote. The court did not agree. Mr. Singh is, quote, a healthy working-age male. He may have a few occupational skills and speak only Punjabi, but he demonstrated resilience and adaptability when he successfully migrated to the United States. Endowed with these strengths, we do not think any reasonable adjudicator would be compelled to find that Mr. Singh's limited family ties outside of Punjab make it unreasonable for him to relocate within India, end quote. And Mr. Singh had also challenged the IJ and the BIA's no past persecution findings. And of course, if past persecution is shown, it would be DHS's burden to establish relocation, so I would think that a remand would be required, given that all tribunals had placed that burden on Mr. Singh to prove a negative and held that he had failed to meet it. Other circuits routinely remand under such circumstances. Apparently unconcerned with burdens, the Seventh Circuit did not believe it needed to even address past persecution. And that meant that Mr. Singh lost his case. And that is Gurkarat Singh v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/immigration review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.